in pursuing the research and completing her, even though it is delayed, was there and permitted by the Pondicherry University, thanks to Pondicherry University and the Honorable Vice Chancellor, the officers of the university. And again, I should also thank the top committee member, Mr. Kasalingam, who has taken all effort. But for Mr. Kasalingam, so this Synopsis presentation would not have taken place. So he has made all attempt to give a light to the scholar and added together Professor Riyazuddin was also so much helpful, and in the last DC meeting he has helped so much to refine the research work, and accordingly all that has been done by the research scholar, and now she is going to present. The title of the research is From Margin to Mainstream, a critical study on Indian constitutional provisions and existing legal framework in protecting the rights of the transgender persons. So she was my first PhD candidate. I didn't want to leave her, and I want to protect and I want to see that she completes the PhD, because two things are there for that. One is about her first registration, so that attachment is there. Number two, she wanted to do a gray area, that is all about transgenders. So how, because that they form a section of people, a group of people. So now I think it is getting increased, the numbers. So we need to have a study, and we need to also make a provision for protecting the interests of the rights of the transgender persons. So on that area she has done, and hope she has done everything satisfactorily. And now she has come here to present the synopsis. And based on synopsis, I request the doctor committee members who are present here to make necessary corrections, and even one or two questions the students here who are witnessing may raise. So again, once again, thank you for all coming here, and I request my scholar to present here.
Thank you so much, sir. Thank you one and all, and thank you so much for the kind words. I welcome all my family and my mother, dignitaries who've been traveling along with me for all these years. Since told me, started me since 2014. It is 2014, sir. The 2 months before the Transgender Act came into play. And actually, all three dignitaries have had an influential part in my life. Long journey of 11 years of sir with me, and Kasalingam sir with me. And Akbar, Mr. Riyazuddin sir has given me a valuable input to really work on the research project. With due respect to the dignitaries and the students community, let me begin my presentation, sir. Thank you so much, sir. My topic, as sir told, is that from margins to mainstream, a critical study on the Indian constitutional provisions and the existing legal framework on protecting the rights of transgender persons. And accordingly, to proportionate the title of the paper, I have next slide. I have just categorized into 8 chapterizations of which it is the introduction. The second chapter really focuses on the transgender's journey. Transgender journey in the path of historical affirmation, and without historical identification, it is very difficult to identify the trans community. So I have made a chapterization revolving around the historical travel of the transgender community. The third chapterization is about the constitutional and other legal framework vis-a-vis to the transgender, which is proportionate to my title. And
Yes, sir. The support.
You can one of the other you can. The fourth chapter is about the international perspective towards the transgender community, which was very vital as a core basis of the 2014 NALSA judgment. And the fifth chapterization is the vision of the Indian judiciary in protecting the transgender. Till now, 2025, the Honorable Supreme Court have constituted an expert committee to relook into the contemporary position of the trans community. So I thought a chapter involving about the Indian judiciary and the comparison of global initiative would be proportionately relevant to convince my research area. And the seventh is about the contemporary realities in the position of the transgender. India being the world have witnessed nearly 300,000 of human species, of which nearly 160,000 species of human species have been identified so far, of which the transgender community constitutes very minimal area to be very well called as a minority, but unfortunately the constitution never demands for that minority identification. Since they belong to the marginalized community, I thought the contemporary reality in the position of the transgender will be proportionately validating my research area. And again, the formal thing is conclusion and the suggestions. And of the suggestions, I have proposed a draft legislation with my source guidance proposal to the Government of India to relook the Transgender Act, not only covering the protection of the transgender community, as also to the protection and against the anti-discrimination thing. And next slide. As I already told, the Homo sapiens is about the 300 lakh years. It is very crucial to look into the society, the social construction of the society, which is obviously patriarchalism versus matriarchalism. It is not about the patriarchalism, which is matriarchalism, but convincingly proportionate to the research area, because patriarchalism and the matriarchalism is nothing but the man and the women coordinated together to target one particular community, nothing but the transgender community. And we, during the draftsmanship of the constitution, really the shocking surprise that it was apparently invisible about the constitutional makers to look into only the normative genders. That is, they looked at the time of the making of the constitution only the biological sex and not about the trans community. The shocking surprise that how come the draftsmen of the Indian constitution have apparently missed the area which was traveling all along. And the next thing is that these communities have been socially ostracized, and I would predominantly call it as social castration of the transgender community. And these communities have been apparently buried, so that it is very minimal people come to the willingness of identifying the community and to gel with them. And the more the community needs is an inclusive identification of the community. That is all they want for. Regarding the terminology transgender, we have to hit that it is not in a recent origin. It is way back actually. In 1990s, it was predominantly identified. The first person was identified as unfortunate to be a psychiatrist and not a legal personality to identify them. And the credit goes to Dr. John F. Oliven. Magnus Hirschfeld also contributed in identification of the transvestites and transsexuals. Even now, people get decepted by having a sex as a replacement of gender and gender as a replacement of sex. And transgender is an umbrella term which invites all sorts of intersexual identification. And transvestite is something which is related to the clothing of a person, and transsexual is the gender identification of the person. So predominantly the transgender can be attributed to the terminology of transsexuals. And from the biological point of view, it is not about the anatomical identification, genetic identification, and hormonal identification. The identification of the transgender community is way beyond. The way beyond is that they have to relook in, leaving apart all this scientific identification, they have to be relooked into the legal perspectives of the terminology. And my research has a limitation. I am not concentrating on the spectrum of the LGBTQ plus community. I'm going to restrict my research only to the LGBTQ and the acronyms, only the T, that's nothing but the transgender. Sex is proclaimed and gender is acclaimed. So whenever a transgender wants to identify the personality, it is acclaimed by the transgender and not proclaimed by the constitution and not by the statutory bodies. And these are the terminologies that the transgender is predominantly called. And we bifurcate India into North and South. And predominantly the terminology used to identify the transgender in North India is Hijra. And down south it is different. You know, Tirunambi, other ideologies which are identification of the transgender community. But uniformly, in the international perspective, the transgender is the only uniform word to identify these kinds of community. And with regard to the 2011 census report given by the government of India, 1,37,465 transgenders are there. The thing is that this is not the concrete information given by the government of India and the Ministry of Home Affairs and the Ministry of Society, Women Empowerment and the Empowerment and Justice. 1,37,465 is an inclusive thing. Someone is not identifying themselves or someone is not willing to reveal their gender, they are also included within 1,37,000. It has been 2011 and 2021, the second census has to take in place. Because of the COVID pandemic, they have stopped the census, and you know, pretty well the government of India is working on the census, and now they have determined to complete up the census by initiating 2025 and to complete in the year 2027. And looking at the mortality rate during the COVID pandemic, And these kinds of, even the World Health Organization has to know a concrete data of these particular transgender communities mortality rate. Next slide, now. Next slide.
Next one.
Yeah, it is about, here I've just given the glimpse of all the chapterizations together so that it facilitates the instruction to lead to the chapterization and a race with an historical trace. Unlike the Western society, which is apparently cocooned about the transgender community, and these kinds of these kinds of lifestyle secret and transgender India have a celebrated lifestyle. It is not that we have given the recognition; they have given the recognition to themselves. And transgenderism is nothing but it includes the terminology like transsexuals, transvestite, hermaphrodites, which is a shocking surprise that even the courts have used the word hermaphrodite. We know as a biology aspirant, hermaphrodite is terminology which is used to identify a gender which is having the gender identification of both. Suppose in case the species have both identification of male and the female, they will be called as an hermaphrodite. For example, the Pisces variety they have, or the seahorse variety, they have both the identification of the sex. The shocking surprise is even the courts have identified the transgender community as hermaphrodites, which is a very, very, very derogatory terminology. And later time only the court realized to replace the hermaphrodites with that of the transgender. In the landmark case called as the Namre versus Superintendent of Police Karur district, the court took an initiation of identifying as to what is transsexualism. It is based upon the identity and not on the biology. So we have to rule out the contemporary visioning of identifying the transgender community in the biological perspective rather than more inclined to the contemporary situation to identify them with a legal perspective. And with regard to the pre and the post-constitutional regime, we have an array of the constitutional provisions before that. I am just bifurcating that after the constitution, before the constitution. Before the constitution, there were crude draconian laws prevailing in the country. For example, the Indian Penal Code, as you all know, one was the draconian statute which was in the 2023 Bharatiya Nyaya Sanhita, and still the roots of the Indian Penal Code still prevalent on the PNS. I'll discuss it in the later half of my discussion. And the other one is the Criminal Trials Act of the year 1871, the Thuggy and the Dacoity Suppression Act, the Murders Outrageous Act. All these things are the crucial, crude, gruesome hand of the colonial regime, penetrating into the social construction or the social inclusivity of the Indian scenario. And regarding the post-constitutional period, some good legislation India have witnessed. For example, the Domestic Violence Act or the sexual harassment of women at workplaces, nothing but the POSH Act, the Transgender 2019 Act, and the Bharatiya Sanhita 2023. Again, coming to the definition of Section 2A of the Domestic Violence Act, it was very primitive ideology that the aggrieved women was believed to be only the biological sex. Only through the intrusion of the honorable courts, it has a wider spectrum of including the trans women, and still, and even now, the belief persists among the society, among the normative genders, is that transgender, the terminology which is proportionate only to the trans women but not to the trans men, is a primitive ideology till the country is facing. And mentioning about the transgender, the international instruments, we have varied array of international instruments, really considering the acceleration or the credit should be given only to the Yogi Katha principle, which took a step forward in the 2006 of identifying the sexual orientation, gender identity, sexual expression to be predominantly considered during this contemporary period. And again, the primitive statutes like the UDHR, which is 1948, and also acclaimed about the human rights. The Constitution do recognize the human rights perspective, is that the human rights terminology is not being identified by the Constitution. Instead, we have fundamental rights replaced by our Indian Constitution. The impeccable approach of the Indian judiciary during the constitutional debate, which ran for nearly for 3 years, that is 2 years of 11 months, 29th November 1948, under Article 9, nothing but the Article 15, they have incorporated the concept called as a reservation to the women and children. It is totally astonishing that the Indian government in the 1871 were focusing on the Criminal Rights Act to be a very crude draconian law, was silent about identifying the transgender community within the spectrum of sex, which is even now continued as sex, even after the Nansha judgment of 2014. And only after many years of passing of the Indian Constitution is only the dawn came in the life of the transgender community in the month of April in 2015. That is nothing but via the Nalsa judgment, where Justice Radhakrishnan and Justice Sikri have took a lead in identifying the broader spectrum of sex by including the gender identification as well. And next come to the transgender and the global identity. And I have restricted my research to a few countries, that is America, United Kingdom, Canada, Nepal, Malta, Argentina, and Portugal, because contemporary ideologies of extending the trans community within their spectrum was identified only by these countries. And we know 31st March is every year celebrated as the International Day of Transgender Day of Visibility, which is apparently connote that these community are still in the darkness. They need visibility not from their community but from the normative gender, which is identified. The terminology used by a transgender activist called as Rachel Cradwell Croker. The credit has to go to her. And as far as Tamil Nadu government is concerned, we celebrate in the month of April, on 14th April, we celebrate the Transgender Day. Next slide. And now heading to the background of the study, which made me to really get into the identification of the transgender community as my research project, is that the term transgender and the rights of a person have undergone a varied of metamorphosis by leaving apart who is the beneficiary of the initiative, which is apparent via the Transgender 2019 Act, which has only 23 sections. The cause title of the Act demanded for protection of rights. But where is the protection given to this transgender community is a question not raised by me, which facilitated by me. Even during the month of 2 weeks back, the Honorable Supreme Court have identified and constituted a committee to relook into the progressiveness and what is the job of the National Council of the Transgender Persons really working. Are they proportionately facilitating the purpose for which they have been established? Everything has to be relooked with the two transgender communities person, one from the state of Tamil Nadu, identifying the honorary position of the expert committee, which has to submit its report within the month of 6. And regarding the reservation policies, again comes an issue with the reservation policies of the transgender community. We don't have vertical approach of reservation of the transgender community. Rather, they have the horizontal approach. Vertical approach in the sense people belonging to MBC will get a reservation. People belonging to BC will get a reservation. SC reservation. It is not a vertical approach. It's an horizontal approach, which means that whenever you knock the door and whichever reservation you claim for, only running to the pillar and post and approaching the court of law, you will be restored with a remedy. What about the people who are not having the approach? What about the people who are not vigilant about these kinds of legal battle? They will be suppressed. And regarding taking that into mind, Mr. Shashi Tharoor have presented the bill in the Lok Sabha in 26th July in 2024. It's still pending in the Lok Sabha, claiming for 1% of reservation governmental establishment. As far as Tamil Nadu's government, the Pritika Yashini case, the first police cop went into the department by invoking Article 16 of the Constitution. Still, how many people is very considerably minimal when compared to the people who are really in their pains. And the credit has to go to the Karnataka, which initiated 1% of reservation to these transgender community with an horizontal, with a vertical approach of claiming them under the category of OBC, other backward classes. And regarding the global benchmark, we need an inclusive, enforceable, right-based approach by curbing off all the discriminatory practices. And it is regarding to the imperative method of critical analysis. India during the time of 2014 and 2019 were imperative when fastening up the passing of the legislation, but they really look into the crucial analysis of the transgender community, but apparently within not from the vision of the legislative bodies. It's a shocking surprise of the derivatives of my research, and it interrogates the disjunction between the legal recognition and the present reality of contemporary social legal implications. And again, coming to the scope of my study, I have restricted, since my title claims for only few constitutional provisions, I have restricted my research to only a few constitutional provisions, that is nothing but the Articles 14, 15, 16, 19, 21 and 29. reason for portion of these articles and few concentrating on the articles will be dealt later. A detailed analysis of the really a legal toxification of the Transgender 2019 Act were done by me by taking into account of 8 minor enactments of the country as well as the major enactments of the country, really doing a legal toxification and deriving of 61 sections with 10 chapterizations with 31 definitions as a draft proposal. And looking into the pre and the post constitutional law, the transgender people has a shift of approach to the landmark judgment. And a comparative understanding is really required to facilitate my analysis of the research. Next slide. Regarding the objectives of the research, I have actually made my 8 chapterization focusing on the objectives of the research to examine the historical position of the transgender community and the data which I claim by legally dwelling on the statutory things and the review of literature of many books by the experienced historians. I come up to the conclusion that it was not the acceleration of the transgender community, it was rather a deterioration of the transgender community. To critically examine the constitutional provisions, particularly, I take into note Article 15, by which I totally believe that instead of focusing on the Article 15, Article 14, Article 15 will give a proportionate validation. Why? Because it was the only article which surpasses and identification of the positive discrimination with due respect to the intelligible differentia is allowed by Article 15 Clause 3 and 15 Clause 4. Even looking at 15 Clause 5 and 15 Clause 6, the answer would be predominantly dittoed out. And next thing is about Article 29. None of the judgment, as the Honorable my resource, my DC members have told me, Article 19, none of the judgment have identified them as a minority community. The connotation of the Indian Constitution is to identify the minority community from the viewpoint of majority and not from the viewpoint of marginalized. If that is the case, it is from the viewpoint of the marginalized section, then majority will never point on the minority. The terminology minority is not to be attributed on the concept of number, but rather than the concept of edging of the transgender community. And regarding the comparative analysis, I've already told that I have made USA, UK, Canada, Australia, Nepal, Argentina, Malta, and Portugal, along with the Indian. And regarding the national and state-wise initiatives, the research topic is very clear that I am questioning about the legislative framework and not on the policy framework. So, to the peripheral understanding of the concept, I have really touched. Next slide. My research problem, despite the NALSA judgment, which identified the transgender community as a third gender, which was way back identified in 2007 itself by our neighboring countries, it is shocking surprise that only after a span of 7 years, India took an initiative, a positive initiative, identifying the trans community as third gender. In that particular judgment, they've identified them as a socially and educationally backward class. But still, even after 11 years of passing of the judgment, there is no commendable change in the position of the transgender community. And regarding the present laws, we need a robust updating of the existing provision so as to taking into account the ground reality which was witnessed by the countries like Argentina, Malta, and Nepal. And Nepal is considered to be the neighboring country which has a fascinating approach of dealing with the transgender community. A self-proclaimed gender is a one which is identified by the NALSA judgment. That is, anybody who wants to willing to change of the gender can go to the district magistrate and give a declaration identifying their gender. But the question here arises is that how many people will really go and identify their gender identification? How about the perpetrators gaming this situation and claiming and misusing of the reservation which is being guaranteed to the transgender community? All these things are the grey areas identified by the researcher in the Transgender Protection of Rights Act 2019, because the act is silent about the authenticity. You know pretty well that Article 21, which protects for a personal liberty of a person, without Maneka Gandhi was the University has so many judgments, without disturbing the human dignity and without making an anatomical search on the body of the transgender, how are the bodies, judiciary bodies are supposed to scrutinize their gender identification and acknowledge one to put him into the reservation clause. And that is the reason India finds it very difficult that in order to open up the reservation clause, you need the test to be identified. But 2014 judgment is very clear that you cannot force a person to go for an SRS by going for as a mandatory sex conversion surgery, because Article 21 prevails in the country, as well as Article 19(1)(a), which talks about expression. Expression is not only about expressing ourselves, expression is also about the way we conduct ourselves, our dressing, our mannerism, our sight, our feeling, our acclamation of the gender. India is misfortunate that it has not identified these kinds of concepts and not even took a strenuous effort in incorporating these provisions. And about the research question, and regarding the legal and positional impact, how does the framing of the constitutional provisions really affect by incorporating a separate clause into the Article 15 would be fair enough in elevating and accelerating the position of the transgender community. With regard to the distinct social, religious, and cultural group,
Carry on. Nicely, you are doing all the best.
Right.
Okay. So she is my favorite student.
yes.
From first year, supporting her.
Thank you so much, sir. Thank you so much. Thank you so much.
So on completion, suggest
Yes, sir.
that our students also know in brief whatever
Yes, sir.
you said in a very fast manner, so they will not be able to understand something. And something we can just brief.
Yes, sir. Sure, sir. Sure,
So
sir.
that
They'll be
my students
facilitated.
can
Sure, sir.
understand,
Sure, sir.
in
Sure.
detail about the.
Sure, sir.
research
Sure, sir.
research.
I'll obviously, sir. Sure, sir. Come on. Next slide. I can get into my chapterization, sir.
Brief and complete.
Okay, okay, so fine. So regarding the analysis of my research about the transgender community, why I was fascinated to do a research on the transgender community. The day one I approached sir to do a research on the transgender community is why, because sir told me that it is a gray area still prevalent on unidentification of one particular community, where the exploitation of the majority starts by the minority getting victimized. So we really want to address, and with due respect to sir's advice, I have formulated a draft proposal wherein which I have identified the reservation policies. It is shocking surprise that the title of the act claims for protection of rights of transgender person, but none of the definition claims for who is a victim and who is an aggrieved, what is violence, what is deviation, what is discrimination. None of the areas have been identified. So I took a strenuous effort on identifying the Forest Dwellers Act and the Domestic Violence Act, Sexual Harassment, the POSH Act, and the SC/STs Act, the Disabilities Persons Act. I took a thorough understanding of all the legislation, and only then I came to a conclusion that all these legislations were compiled together and was formulated by as a Transgender Act. So, which was totally shocking surprise that all these nuances were compiled together and bundled up. They want to put a robust legislation. They want to have an imperative that it is just a watershed. It is not at all serving of the community. That was the derivative I uploaded out of my research area. See, to be more prevalent, there are various countries in around the world which took in legislation. For your knowledge, I'll comment on certain judgments which will be initiated for you to do a research, and you can also submit a proposal. And you know Keshavananda Bharati case pretty well. It was the case which was identifying the doctrine of basic structure. But where is the basic structure here? When the entire act has its volatility and has its own viscosity and is not concrete enough, where are these people are about to? When you can stand on a platform, only then it is a platform. How about the platform which is a very iceberg and volatile? Who will trust those platforms? The act, for the sake of serving the community, was rushed and passed in the year 2019. But the proportionate results of these acts serving the community is a million-dollar question, which is victimized by the transgender community. Another one is that you all know the Vishaka versus state of Rajasthan. You know the sexual harassment thing, but this act as not proportionately was coined to serve the trans community. It was in the year 2013 the bill actually passed. The thing is that even then the transgender community was surviving. It is shocking surprise that in the immediate next year, the Honorable Supreme Court is passing a judgment serving them as a transgender. Where the parliamentarians were silent about identifying them a year back. If they could have done it, nobody would have raised the question that even now Section 2A aggrieved women as per the Domestic Violence Act, they want to incorporate them within the ambit of Section 2A, which talks about aggrieved women. They have to knock the doors of courts of law. Every time knocking the doors of court of law is not a resolution of the problem. You know pretty well that in constitutional law, the second half of the constitutional law, when there is no particular legislation surviving on the country, then the decision of the Honorable Supreme Court prevails to be the law of the land. A law is there, then why is Supreme Court here? Still now, even as I already told, 2025 also, these people are rushing from pillar to post to endorse their remedy, to endorse their voices. And still now, these community voices are throttled and they are voiceless. That is the ground reality. And again, the landmark judgment. For a easy understanding of the particular thing, I am telling that what was the scenario before Britishers period, what was the scenario after Britishers period to 2009, the famous landmark judgment is Nash Foundation case law. 2009 to 2013, the expert committee constituted for proposing a draft proposal for these kinds of problems for the transgender community. And 2013 to 2014, 2014 is the landmark Nalsa judgment identifying them as a third gender. 2014 to 2018, 2018 is nothing but the Navdeep Singh Johar's case and the Suresh Kumar Kaushal case, which is again a landmark judgment. After 2018 Act passed and 2019 to 2025, still they are oscillating with their rights. You know, Section 377 of the Indian Penal Code, and you know pretty well about the Bharatiya Nyaya Sanhita. Does Section 377 has its place in the Bharatiya Nyaya Sanhita? No, it does not. It is a colonial regime that Indian Penal Code, via the Buggery Act of England, incorporated Section 377 into the Indian Penal Code, which proportionately the same-sex relationship was prohibited. But the Indian government in the year 2023, via the Bharatiya Nyaya Sanhita, have taken Section 377 outside the parameter via the Criminal Amendment Act 2018, which was decriminalized the the same-sex relationship. Now you can have a consensuous sex relationship. I am telling about a scenario till 2023. I'm not telling a scenario now. You have to make a close look into it. Before 2023 till 2018, Navdeep Singh Johar judgment has decriminalized. I am not telling legalized. I am telling that decriminalized the provision of Section 377 of Indian Penal Code, which is very, very clear that Section 377 allows a consensual sexual relationship. But does this Section 377 is taking a place in 77 of IPC? I am posing a question that whether the person who is living with same-sex relationship before the passing of 2023, what is the status of the marital state? What is their family? What is their adoption right? What is their stand? Are they supposed to get criminalized? The question is, it is an absolute emptiness in the Bharatiya Nyaya Sanhita. The Act demand for proportionate amendment. Why? Because it is neither penalizing nor facilitating. Just because Section 377 has been derooted from the mean that people can have whatever life they want. Where is the question of check and where is the question of balance here? The government of India claiming that we have demanacled the draconian harshness, claim to once again put the transgender community in a much more darker place where they really asphyxiate to have an ounce of oxygen to survive among the normative genders. And again, there is a landmark case of Pakistan, Dr. Muhammad Aslam's case. It was the first reported Pakistani case where even before our country identifying them as third gender, Pakistan took a leap forward by identifying them as the third gender. And again, you all know Indian Medical Association versus Union of India, which is a landmark case, which talks about the proof of a professional autonomy rather than a personal autonomy. The doctors have to be much more professionalistic in approaching the trans community and not taking it personal by putting them by infringing of their Article 21 by mandating the sexual reassignment surgery. And again comes the landmark judgment, which identified that suppose in case in the reservation policies or in the application form, we happen to see that men and women. Where is the column of the third gender community? The passport authorities have incorporated the concept called as E earlier before, but only after the 2014 judgment there was a concept called as E. But here the question arises that who is this? It is trans men or trans women. It is a myth and a notion by the general public that whenever people are talking about the transgender, it is proportionally attributed to trans women but not trans men. Again comes the disparity among the community that the trans women have been prioritized facilitatively and not the trans men, because India is a culturally ethnic soil where we prioritize women to be taking a lead, and that has its shadow reflection on the reservation policies identified to the transgender community as well. And here, Vishwanathan Krishnamurthy was the state of Andhra Pradesh. The state of Andhra Pradesh, the High Court of Andhra Pradesh, has to be credited in firstly identifying that when you don't have a reservation policy for transgender people, you fit them into the women category. Again, a question arises that suppose in case a transgender women belonging to the BC category is not being identified as a transgender in their application form, can she be fit in the category of BC women? Then how about the reservations guaranteed by the Indra Sawhney versus Union of India case law to the women who's already there in BC category? Again comes in overlapping. So the Indian government and my research is facilitating to do all these nuances to abridge the purpose of the act and to serve the community. The only motto of this community is not being a falling a prey for victimization. The other case law is the Karnataka Sexual Minorities Forum versus the state of Karnataka. We know one of the act prevailing in the Karnataka state is Karnataka Police Act, Section 36A, identifies the transgender community who's begging, dancing in the public as UNAT, and they have to be put behind the bars. So Karnataka government has took an initiation in finding this particular section is unconstitutional as it violates the basic need of right to livelihood guaranteed by the Indian Constitution. Again comes the case, a very important case law is that Chameli Singh versus State of Uttar Pradesh, where the court identified that Article 21 of the Constitution not only guaranteed the right to life but also the right to shelter. Where was this article at the time of COVID pandemic, 2019? These people again have approached the court of law by filing a writ petition to claim for the basic need, nothing but the ration cards. So now only few states of India has took an initiative of giving 2,000 rupees per month for the transgender community. And regarding the data, I've already you can look into the site which is available by the government of India. So far, very minimal people have just took the benefit of this national transgender portal. Yesterday night also I witnessed very minimal people. Only 30 plus states have come really forward in identifying the transgender community. As of now, you don't have a national pension scheme available to the transgender community. We know pretty well for child helpline, we call it 1098. For women helpline, we have numbers. Regarding the national helpline for the transgender community, we are not having a concrete helpline number to really purpose the transgender community. For even that, they have to approach the non-governmental organization. If every time the NGOs are not accelerating, they are reducing the job. It is not that every time the state has to dwell on the NGOs and really do the purpose. Then what is the statutory bodies? And regarding, I'll get into the conclusion.
Okay.
I have, yes sir. Yes sir.
And what do you want to suggest?
Yes sir. I am suggesting actually a proposal. Last conclusion conditions. This is a compilation of it is a It is a peripheral note I have just given. I've elaborately extensive done a research on just coming up to this conclusion that an absolute liberty on the personal autonomy is mandated. Your sex is not fixed by you. Your sex is based upon your XX chromosome and the XY chromosome. It is fixed by your parent. But your gender is your choice. So the state cannot intrude into your personal liberty by forcing you that whatever gender, whatever sex your parent is given, you have to acknowledge that till your lifespan. One of the country named the New Zealand. India is silent about this concept. New Zealand has took a step forward that when you are converting your gender, this is a landmark judgment vitiating the judgment in Corbett case, where the Corbett case told that your biological sex can be changed at any time you want. But New Zealand judgment told that your biological sex, once changed to gender recognition certificate by the government, you cannot retrieve it back. So again, India is a democratic country. We are not a dictatorial country. We are just given the absolute liberty of keep on metamorphosing. Already told of the section 370 by the parliamentarians of incorporating the particular section in the ambit of the Balkanaya Sanhita, and a separate clause proposing, just like Article 15 clause 3 and 15 clause 4, special reservation for women and children, a special and the SC and both backward community and economically backward community, a special clause has to be incorporated as 15 clause 7. You know pretty well that till now we have 15 clause 6 and 15 clause 7 is the proposed thing. And here comes, I am not identifying them as a minority. I am going with words of the Nalsa judgment, where the court identified them as social, religious, and cultural identity. As you all know that Article 29 talks not only about the cultural, religious minority and the linguistic minority, they also talk about the cultural minority. And here I widen up the scope of minority, not on the concept of figures, not on the concept of numbers, but on the viewpoint of marginalized. And that is the important hypothesis. And a broader spectrum of Article 29 is required. And again, employment opportunities to the transgender community, very, very minimal. Article 16 clause 4 has to be relooked. And again, a draft legislation, and this is the legislation under search guidance. I have prepared the transgender persons protection of rights, prohibition against discrimination, preservation of social security. Earlier, the title of the act was Transgender Persons Protection of Rights Act 2019. I have extended the ambit of the act by identifying the discriminatory practices against the transgender community and the preservation of social security by endorsing the chapter 4 already there in the 2019, which identifies the welfare measures taken out by the state. And accordingly, I have proposed 37 definition clauses by identifying 8 statutory legislation given by the Government of India, and with 61 sections and 10 chapterization. The main thing is that what I identified based upon the 2019 Act is protection of rights and the offences and penalties of the Act. You call the Act, even the SCST Act or any particular Act, the Act is considered to be very strong and very strenuous. But where is the penalty? The penalty is very minimal, even the Protection of Civil Rights Act, even the Prevention of Atrocities Act. So, though this legislation is given a punishment of only 2 years, then where is how will the perpetrators as it is a bailable offence? The perpetrators can easily withdraw the situation. So, we need a policy making that relooking of the offences and penalties is required. And again, the National Council for the Transgender Person has to be recoiled up, and monetary surveillance of the transgender community with 24/7 helpline is a need of the hour. And I wrap up my thing by giving my thanks, wholehearted thanks, and please give a round of applause to my guide, please. Sir, you are very, very humble, but I am intended to thank you, sir.
Only one clarification, not, but on your behalf, I clarification.
Yes, sir.
Because it is only standard to the stage. So whatever clarification is, so that if happens to be positive, it can be corrected, and when presenting the full PhD thesis, so that can be done. So you say that the transgender can be classified as a cultural minority
Yes, sir.
in terms of Article 29.
Yes, sir.
So how do you justify it? So your justification in simply two sentences.
Yes, sir. So in TMI Pi Foundation case, the terminology minority should be treated as state-wise and not national-wise. Since the ambit of minority is proportionate to the people belonging to Christianity, Buddhism, Jainism, and Sikhism, I am not identifying them within the ambit of by limiting the scope of minority. I am extending
Cultural
the
minority.
they are cultural minority by extending the Bal Patil's case where the court identified them as a linguistic or religious minority is based upon again giving the ruling of the TMA passed by foundation and Bacha case the court stressed that the point I am highlighting here is that the court stressed on the dynamic nature of law by giving an importance to the reflection that the law should be in such a way that it should be accommodative to the social change. If that is the case, at the same time, the court again identified that the court must take care of the oppressed community when they are identifying such a social change. If that viewpoint, keeping the Badshah case into my mind as a lead, if it is the law should be in such a way that it has to have a metamorphosis with the civil concreteness, you know our constitution is rigid and flexible. They should not be rigid in interpreting the terminology minority, so far interpreted on the numerical counts about the quantum and not about the quality. If it is about the quality, then the law has to be relooked by inviting them with due respect to the Nalsa judgment, which has already identified them as cultural religious identity. I am proposing them to be identified as sexually oriented cultural identity within the spectrum of minority. If sex include gender, as per 2014 judgment, though they are two different concepts, why not minority include the purview of identity? That is my humble submission, sir.
I think you can understand that these transgenders who are, I think, not see on the road here and there, in temples everywhere. So they now form a group. Day by day, they are increasing. So their interests must be protected. So they can't be isolated in the society. They are a part of the society. So now she is doing a research on that. And the law based on 2019, there is a law for protecting the transgender. She said that it is totally inadequate. It does not operate. And that is how she has also prepared a new law, a draft law, so which can satisfy all the requirements, whatever like the 2019 law is now replaced by her draft law. So ultimately, she wants to say that they form a group and that they are culturally a minority group, and the definition or interpretation that she has given now. So I think you'll be able to understand. So as of now, as a non-law student or as a law student, you must be seeing a transgender in a different connotation. But now you understand that they are also part of the society and they deserve certain rights that is guaranteed in the constitution. So that is the purpose of the research work. So we'll all appreciate the research work. And any questions, you can just
Any questions you can ask me, I'll clarify your questions. Any questions?
So I want the students to raise some questions. So they are not just exposing the results. So when you கேக்குறதுனால அவங்க வந்து நம்ம ignorance expose ஆகுதுன்னு
I can tell
So
you
just highlight the question.
உங்களுக்கு ஏதாவது doubts இருக்கா இந்த app பத்தி? No, I have to again ask my student to really raise me questions, and both of my students are sitting here. I must tell them to raise
Some questions you can throw.
ஏதாவது doubts இருக்குது if you very well இது உங்களுக்கு இந்த ஆப் என்ன சொல்லுதுன்றது புரிஞ்சுச்சா? என்ன நமக்கு இல்லன்னு புரிஞ்சுச்சுங்களா உங்களுக்கு? என்ன இல்லன்னு நினைக்கிறீங்க?
In social aspects, how to rectify this problem in your research now?
My
The
research
social
is
aspect is one thing, but it's one duty and law aspect.
law aspect.
Yeah, on a legal aspect. Social aspect is only when the people
mine is not
of
about
this
empirical
country
research, mine is purely
accept,
doctrinal.
So even the SSC Synopsis Act is there, and every year it says number of cases are getting more. Every year it is increasing as per the NCRB data. But that is not where society must accept and adopt, and it is an inclusive development. It is not exclusive. So they should not be out.
It is a broader umbrella term. We don't have an actual concrete definition of the term. Do you really know what is the meaning of a transgender?
Then only the question will arise.
Do you really know the meaning of a transgender? There is no particular. It is actually a pseudo identification. Why?
The
Because there is no
transgender
concrete.
meaning தெரியுதா உங்களுக்கு? Who is a transgender? The transgender 2019 ஒரு சட்டம் வந்தது. அந்த சட்டமும் வந்து inadequate ஆகுது, ப்ரொடெக்ஷன் கொடுக்கலன்றது தான் அவங்களுடைய grievance. அதனால தான் ரிசர்ச். So from the beginning till now, what is the improvement and what is the protection? So that is guaranteed by the constitution. That's done. So another, you have to understand that concept. Start doing research. Start looking to some articles relating to transgender.
Of course.
So you can also contribute. So the formula of vote of thanks.
No question.
Very good.
Yes, definitely.
So presentation go. Right of paper.
I take this opportunity to congratulate Mrs. N.REENA Roy. I'm sorry. Miss N.REENA Roy, PhD research scholar, who is doing a critical study on Indian constitutional provision and existing legal framework on protecting the rights of transgender person. We congratulate her for the research work done and the presentation of this synopsis. I also take this opportunity to thank Professor Dr. S. Srinivasan for guiding her to do this research, and to all the students and fellow faculty members here to attend the synopsis presentation. Thank you all.
Thank you so much. It's a very,
Thank you for your passion sitting here.
it's a very peripheral vote of thanks to sir. Please again clap for sir. Thank you so much, sir. It's not for you. It's not for you. It will never happen, sir. Thank you so much, sir. And thank you for all the people who have turned up to patiently listen to my presentation. Thank you so much.
REENA.
Sir, it's like I'll honor you, sir. A very tall, small token of my respect, sir. Thank you so much. Actually, thank you so much.
Speak it up. Keep it and speak it up.
Yes,
Then you can have your
please, happy